The state petition is accordingly dismissed. However, it is observed that the authorities under the aforesaid Act of 1971 would decide the pending proceedings in accordance with law and without being prejudiced by the dismissal of the state petition. I have held that the writ petition is not maintainable.
Fifth case from supplementary list item 7, first appeal 271 of 2023.
One confusion which was there yesterday, my learned friend had said that the stand of Steel Authority of India Limited that they will supply the material only after the completion of the criminal proceeding was not taken by way of written statement. It was by way of written notes of argument. That was argued by my learned friend. However, this is incorrect, Manas. I would show from the order itself, Exhibit 4, that in their written statement they have taken this stand. That is categorically stated. If my notes can have Exhibit 4, internal page 4. On oath they have taken this stand. Exhibit 4 means para 2, the learned court discusses the plea filed by us, and at para 3, the learned court discusses the written statement. Para 3 bottom, that page 4 bottom, it says of the Exhibit 4, the judgment malus, which was rendered in the earlier round.
Just a moment. Judgment
I have a better copy, I'll supply this copy.
दिखाई जरा कैसा कॉपी है टाइप किया हुआ
Amal's type. I think this is original. Last bit the signature की भाषा है.
This is not original.
Must be typed.
इसका एक कॉपी तो देना पड़ेगा ना आपके पास सॉफ्ट कॉपी है क्या इसकी
You can get a soft copy prepared if you want. Direct. I'll get it prepared.
Will you please get it?
I'll read one para 3. The learned court records प्रतिवादी ने अपने प्रतिवाद पत्र द्वारा वादी के वाद का विरोध करते हुए कहा है कि so it discusses the written statement and now that page 6 it says इन्होंने वाद पत्र की कंडिका 13 एवं 14 के संबंध में कहा है कि जब तक फौजदारी मुकदमे का निष्पादन नहीं हो जाता है तब तक प्रतिवादी कंपनी वादी को सामानों की आपूर्ति करने में असमर्थ है।
आगे
साथ ही चूंकि संविदा अभी तक वर्तमान है, अतः सिक्योरिटी मनी का पैसा वादी प्रतिवादी से पाने का अधिकारी नहीं है।
आगे
इस तरह वादी द्वारा दावा किए गए सूद अवैध है, जिससे वादी प्रतिवादी से विधि अनुसार पाने के अधिकारी नहीं है। इन्होंने वाद पत्र की कंडिका सुवंशों में वर्णित तथ्यों के संबंध में कहे हैं कि वादी प्रतिवादी से दावा किए गए रकम मूल्य सुवंशों पाने के अधिकारी नहीं है। इस तरह वादी को ना तो कोई वाद है, तुक है, और वादी जब तक फौजदारी मुकदमा लंबित है तब तक कोई भी अनुतोष प्रतिवादी से पाने के अधिकारी नहीं है। अतः वादी का वाद खर्चा के
अनुतोष is
साथ
what? अनुतोष is what?
Relief. Not intended for any relief.
अतः वादी का वाद खर्चा के साथ खारिज योग्य है।
आप ना लास्ट का 3 पेज पढ़िए।
I am reading from page 17.
Yes.
यह
भी स्वीकारात्मक
स्वीकारात्मक तथ्य है कि संविदा के अनुसार प्रतिवादी कंपनी का शेष सामान अर्थात that is 400 and something metric ton कन्वेयर बेल्ट्स वादी की आपूर्ति करना था। अर्थात विधि अनुसार यह सामान जिसे प्रतिवादी कंपनी ने वादी को नहीं दिए उसे पानी के वादी अधिकारी हैं। जैसा कि पूर्व में विनिश्चय कर चुका हूं कि प्रतिवादी ने अपने प्रतिवाद पत्र मतलब दिस रिटन स्टेटमेंट एवं अपने बहस के मध्याह्न सिर्फ एक ही मुख्य बिंदु पर अपना प्रतिरक्षा रखते हुए दावा किए कि चूंकि उपरोक्त वर्णित फौजदारी मुकदमा अभी लंबित है, इसीलिए प्रतिवादी वादी को संविदा के तहत कन्वेयर बेल्ट्स देने में सक्षम नहीं है। लेकिन उपरोक्त विनिश्चयों से स्पष्ट हो जाता है कि इस वाद में वर्णित मुख्य मामला फौजदारी मारापाड़ी थाना केस संख्या 1600 में अंतिम प्रतिवेदन तथ्य के भूल करके समर्पित कर दिया गया है तथा वादी एवं प्रतिवादी कंपनी के सभी कर्मचारियों को इससे उन्मुक्त किया जा चुका है तथा यही मुख्य एवं आधारभूत फौजदारी मुकदमा था जो मिथ्य पाए गए और उसके बाद वादी ने सामानों की आपूर्ति के लिए व्यक्तिगत रूप से संपर्क भी स्थापित किया तथा वकालतन नोटिस प्रदर्श संख्या 5 भी प्रतिवादी कंपनी को भेजा। लेकिन प्रतिवादी कंपनी ने ना तो बचे सामानों की आपूर्ति किया और ना रुपया ही अदा किया। प्रतिवादी ने अपने प्रतिवाद पत्र एवं अपने बहस के मध्याह्न स्पष्ट रूप से दावा किया है कि उभय पक्ष के बीच संविदा अभी अस्तित्व में है। तभी तो यह न्यायालय ये विनिश्चित कर चुकी है चूंकि संविदा अस्तित्व में है, इसीलिए वादी प्रतिवादी से सिक्योरिटी मनी का मूल्य 50,000 रुपये पाने के अधिकारी नहीं है। तब तो यह भी सत्य है कि विधि अनुसार वादी प्रतिवादी से संविदा में वर्णित शेष कन्वेयर बेल्ट्स वर्णित मूल्य पर पाने के अधिकारी हैं। उभय पक्षों के वादों में यह भी स्वीकारात्मक तथ्य सामने आता है कि किसी भी न्यायालय द्वारा प्रतिवादी कंपनी को वादी को सामानों को आपूर्ति करने से निषेध नहीं किया गया है। फिर इस बात पर आश्चर्य होता है कि प्रतिवादी कंपनी ने क्यों नहीं संविदा में वर्णित सामानों की आपूर्ति वादी को किया। अतः यह न्यायालय ये अभी निर्धारित करती है कि चूंकि संविदा अभी अस्तित्व में है और प्रतिवादी भी इसे वैध एवं सत्य मानती है, इसीलिए वादी संविदा में वर्णित शेष कन्वेयर बेल्ट्स 400 and something क्वांटिटी संबंधित मूल्य पर वर्णित शर्त पर पाने के अधिकारी हैं। लेकिन वर्तमान मुद्रावाद में शेष सामान को पाने के लिए अनुतोष की आकांक्षा वादी ने किया है, लेकिन वर्तमान मुद्रावाद में संविदा में वर्णित शेष कन्वेयर बेल्ट्स मेट्रिक टन प्रतिवादी द्वारा वादी को आपूर्ति करने का आदेश नहीं दिया जा सकता। इसीलिए वादी को यह ऐच्छिक एवं सक्षम अधिकार होगा कि वे इन सामानों को आपूर्ति
On
के
the
लिए
same rate it cannot be supplied. This is the finding.
No, Manoj, finding is कि in a money suit, that is what the court says. In a money suit, court says that I am not, we cannot direct specific performance, and therefore, Manoj, it gives the right to us to bring another civil suit in case the opposite
आगे
side.
आगे बढ़िए थोड़ा सा और आगे.
इसलिए वादी को यह ऐच्छिक एवं सक्षम अधिकार होगा कि वह इन सामानों को आपूर्ति के लिए प्रतिवादी कंपनी से पुनः प्रार्थना करे. So my right is reserved.
आगे बढ़िए.
अगर प्रार्थना के बाद भी उन सामानों को संबंधित मूल्य पर आपूर्ति नहीं करते हैं तो मतलब संबंधित
आगे
मूल्य
आगे बढ़िए.
तो उन्हें वैधिक एवं ऐच्छिक अधिकार होगा कि वह अलग से दीवानी वाद प्रतिवादी पर दायर कर उपरोक्त सामानों को वसूल कर सकता है. अतः उपरोक्त विनिश्चयों एवं विचारण के आधार पर यह वाद पद वादी के पक्ष में एवं प्रतिवादी के विरुद्ध विसूचित की जाती है तथा यह न्यायालय इस अभिमत का है कि वादी प्रतिवादी से दावा किए गए सिक्योरिटी मनी मूल्य ₹50,000 को छोड़कर शेष राशि ₹200 12% सालाना सूद के हिसाब से दिनांक 1980 से रकम की वसूली तक पाने के अधिकारी हैं. लेकिन इनका जो अतिरिक्त अंतोष शेष कन्वेयर बेल्ट्स का डिग्री पाने का प्रश्न है, उसके लिए वादी अलग से वाद ला सकते हैं अगर इनकी प्रार्थना पर प्रतिवादी कंपनी वर्णित सामानों को आपूर्ति नहीं करती है.
उसके बाद पहला प्रार्थना कब की है आप?
मतलब एग्जिबिट 10 मतलब
What is the date?
दिस इज 10 to 1993.
This is exhibit.
10.
ये मनी सूट का क्या नंबर है? It is specific performance or money suit?
मतलब it was a money suit with specific performance, but the learned court had, since it was captioned as money suit, the court took the view that it's a money suit.
Money suit number?
45 of 1983. Months.
45 of 1983.
The judgment dated is 9th April 1992.
9/4/1992.
2.
Thereafter you applied when?
Manoj in 93. Manoj,
Exhibit 10.
10 to 1993.
And this money suit is exhibit 4.
Exhibit 4.
10 to 93.
May I read? This Kailash Corporation Limited. It's a letter head.
Just a minute. Exhibit 10. 10 to 93. So which portion do you want to refer to?
Manoj, para 2 onwards, Manoj. Para 1 is the details of that order, Manoj, the order in the money suit. Para 2, that for taking delivery of the balance quantity of 495 metric ton of used and conveyor belts, your officials are saying that the supply of balance quantity of the materials cannot be effected while the criminal case being Marafadi PS case number 151180 is pending, and the delivery will be made as per the outcome of the case. We have been advised by your officials to wait till the disposal of the case for lifting of balance material of contract as per procedure. That we are ready and willing to deposit the material value installment as soon as communication is received from your end. In this regard, as per procedure and terms and conditions of contract, it is therefore submitted that while we are waiting till the outcome of the criminal case, you and your company are stopped from taking any adverse action in the matter. So thereafter,
It was served on whom?
to the managing director of Steel Authority.
Postal receipt? Not there.
Postal receipts are not there also. This has not been objected now. So exhibit 10 it was not.
Anyways,
Well,
so
thereafter,
again, you see, the trial court judgment is very clear on the fact that final form has been submitted.
in one case, there were two criminal cases. In one case, final form was submitted by the time the judgment in the first case came, 92.
There is no mention of the other case in the earlier money suit.
No, there is. There is the mention. That is what I had read. In the written statement, they mentioned the case
Maybe, you see, but in spite of that, the court only discussed one criminal case, filing of final form in one criminal case, and said that that cannot be an excuse for not giving you the
number.
material. And the court says that since it is not a case for specific performance of contract, and therefore they will not.
In the money suit, court said that
Yes, in the money suit, they will not ask them to perform the contract.
they gave us the liberty.
Although it was your specific relief that you were seeking for supply of the
balance.
material, then under such circumstances, why did you file an appeal against that?
But it's because court gave us the liberty to approach them, and if they.
So therefore, if the court gave you the liberty to approach them, then you should not have waited for the disposal of the criminal case.
No, since-
Because the cause of action triggered. Because now you are approaching them not by virtue of any contract. You are approaching them by virtue of the order of the court.
we approached them
Yes.
by the virtue of the order of the court.
Yes.
They imposed a condition that we will supply after the disposal of the other pending case. Now, we somehow it appears we have agreed to that condition. So the
See,
contract
this-
stood novated minus to that extent. That parties they told us that we will supply after the criminal case. We also agreed. Okay, fine, you apply.
So
you
now
supply.
we have reached a situation that in 2015 that case has been disposed
been
of, and now you say that you have a fresh cause of action.
I have a cause of
You
action.
have a cause of action by virtue of the order passed in the money suit, right? That was your cause of action.
My
To apply
To
afresh,
to approach.
to approach, right?
So I approached.
And then you approach and you say that you since another criminal case is pending, and therefore
They
the
was-
matter deferred.
They said.
So
and
you
I
were
ex-
you
I
were
kind
not
of
keen
accepted.
on you were not keen on accepting the material at that point of time. You could have filed a petition for you could have filed a fresh suit. So far as this aspect is concerned, that in spite of this, the direction, the court has already given a liberty that if they do not supply, then you will have a fresh cause of action. But you do not avail
I
that.
could have filed the suit, but it appears, Manoj, that we accepted their condition and the contract stood novated that now the delivery
Was
will
it
be
your
made.
case that the contract stood novated
It
and there was a
appears-
change of terms and conditions of contract?
It appears, Manoj, from
ऐसे
the,
appears नहीं होता है ना. Ex parte
fact-
proceedings में बहुत सारी चीजें देखनी पड़ती हैं. It is not a contested case. Ex parte में everything has to your mere submission, novation of contract by itself requires evidence to be proved. Now at this stage you cannot say that the
If-
contract stood modified.
Manoj,
or-
if this exhibit 10 is seen, Manoj, their offer.
And this
of-
particular letter, what was the mode of dispatch?
It says registered post. Manoj.
Where is it? Where is the
And-
registry receipt?
The registered
Because
post
this is a very important document.
is an important-
Then
is an
where is the proof of its service? When you refer to a letter, right? It is the ball is still on your court to prove that at least it has been dispatched. if not service. Where is that registry receipt? You write registered post, that is sufficient.
The registered post is not being filed. And it has not been objected also.
May not be objected, but any plaintiff has to prove his own case completely to have a degree. Your entire case is based on this letter. And this has not been proved to have been even dispatched. Once you say it is by registered post, the matter all the more becomes serious. There is no receiving. There is no, the receipt of the registry post is not there. And who has exhibited this document?
Once we plaintiffs.
Plaintiffs means who? The signatory of this letter.
No, not the signatory.
Then Prem Kumar has been examined.
But Prem Kumar was ill, Manoj. So
He has not even come to the court that yes, I have dispatched this letter. Have you exhibited your registered, dispatch registered? You are a company?
Manoj, it's a proprietorship firm.
Maybe. But the dispatch and the service of this letter has not been proved.
That service, one of the postal receipts ought to have been brought.
Yes.
So,
And the consequences are very serious because you are imputing so many things, you are putting so many words in their mouth.
these conditions that we will supply after the disposal of the criminal case is there in the written statement itself. I am not imposing a new condition.
No. That
Their
was
written
in the
statement.
written statement in the previous suit.
Indeed, madam.
That will not be read into this. In spite of that they will supply after disposal of the criminal case, the court decreed. Rather, they should have been agreed by that if that was their
They should
stand.
have challenged, madam.
Right, but in spite of that stand, the court decreed. So that cannot be a reason for refusal of supply to you. And if they put the same condition to you again, and again you abide by that, then how do you have a fresh cause of action to that effect? Your entire cause of action is the decree in the money suit.
Money suit gave us the liberty to apply.
That's a part of the decree.
That's
a part of the
decree is only on the terms of money.
No, let
As
them
far as
know.
the judgment is
Decree
concerned,
cannot be only in terms of money, no? It just can't be. That liberty has to be incorporated in the decree also.
Decree is exhibit 4/1. But Malak, that liberty was given to us by way of judgment. I am not disputing that. That liberty was with us. The only issue was because they were still laying down the condition that we will supply after the disposal of the case, and most importantly, they were retaining our deposit. They never terminated the contract. They retained our 50,000 since 1980. If they had a stand that our contract should terminate it, they should have returned our security deposit.
That is a separate thing. That they
They
should have
never-
returned your security.
They never returned it. The judgment categorically records their statement that they say that the contract is valid and subsisting.
In this suit also you are seeking refund? As an alternative plea, I suppose?
Yes, of 50,000 along with interest. I am seeking.
You cannot retain this 50,000 by any means. You have not terminated the contract, you have not forfeited this.
I will answer this question.
You cannot retain this.
I will certainly answer the questions. Let them come.
So all the while the contract was pending and it was subsisting, and the judgment in the other criminal case came in 2015, and immediately thereafter, by way of Exhibit 6 and Exhibit 7, we requested them now to supply, since the only condition which they were laying down was over for delivery. And since they did not supply, we came before the suit.
That's all.
Well,
Yes, this is a pay account. It's a suit for specific documents. Now the leadership will first see whether there is a contract of existence or not. Because whatever, if the contract cannot be executed, then only alternative relief can be granted. It's not a case, it's not an original civil suit where the relief can be granted.
We'll see the prayers.
Yes.
Let us see the original prayer.
Yes. Leadership in the memo of appeal itself, that is at page 43. A decree may be passed that the contract dated 20/2/1980 is still subsisting and the defendant is legally bound to supply the material to the plaintiff in accordance with the terms and conditions of contract. So the sine qua non requirement is that there has to be valid and effective contract. If the contract is there for some reason, suppose frustration, impossible to perform, if not there, then the discretion comes into play for allowing alternate relief, compensation or whatever it can be. Now, kindly come, what is contract? Whether the NIT is
So
a
you read the relief.
Yes, then a decree may be passed in favor of plaintiff directing the defendant to supply the remaining contractual material 495.450 metric ton at the contracted rate. A decree may be passed directing the defendant to pay compensation in addition to supply of the material as defendant failed to supply the material as per the contract. A decree may be passed directing, and then they have amended their prayer. 34D is one page prior to it. That a defendant since 28/1/1980 on side are enjoying the security deposit amount.
And a refund of 50,000 with interest
and
at
a
the rate
refund
of
of
18%.
50,000 given by the plaintiff, and on after side the defendant are not performing their contract obligation of delivering the said materials of the plaintiff, the defendant can not partly rely on contract which favors them and not perform the other part of contract where they have contractual obligation. Therefore, by way of compensation, the plaintiff is also entitled to payment by the respondent of interest at the rate of 15% per annum compounded annually on the said amount of rupees 50,000 since 28/1/1980 along with the principal amount of rupees 50 till the date of the actual payment of the plaintiff. I think only D is there. Yes. Yes, then F and G is also there. A decree may be passed directing the defendant to pay the plaintiff by way of compensation of amount of 1,40,46,07 towards loss of earning of profit and rupees 20 lakhs towards the loss of reputation, goodwill, mental harassment or by other compensation as this honorable court may deem fit in the interest of the plaintiff. A decree may be passed directing the defendant to pay to the plaintiff by way of compensation an amount of 50,000 along with compounded interest at the rate of 18% per annum from 28/1/1980 till the date of payment of the said amount to the plaintiff. So these are the periods. It's a suit for specific performance of contract. Now, kindly come
And
to
also suit for damages. Damages and refund.
when
He's claiming damages, he's claiming refund.
only when there is a contract, then the equitable relief will flow. If there is no contract, then a suit for specific performance, there can't be a money decree.
You see, he's claiming that relief, that amendment was allowed.
Yes.
The
And
nature
prayer
of the
is
suit
added.
had substantially changed.
Yes.
You were not agreed by that,
That's
right? You were not agreed by that.
Since
Now you are facing a situation where there is a suit for specific performance of contract. There is a claim for refund of 50,000 rupees with
Yes.
interest, and there is a claim for damages also.
Yes.
All
Now-
these things are there in one suit.
Now-
Whatever be the title of the suit, we don't bother about.
Yes. Now the ladyship will come to para 8 of the plate. I will refer 7-8 paragraphs
Of
the
the?
plate because the plate has place. Only the date and quantity ladyship.
Para number?
Para 8 page 30 of the
Para 8.
Yes. White letter dated so and so, letter number so and so, dated 20/2/1980, the then controller of stores of defendant company communicated to the plaintiff that the offer of plaintiff for purchase of 740.800 metric ton. So this is the total quantity. 714.800 metric ton of used and old conveyor belts of assorted size on as is varies basis at the rate of 6650 plus. So this is the quantity and this is the rate disclosed in the claim. Now ladies will come to para 9. That in the aforesaid letter, defendant instructed plaintiff to lift 50 metric ton of used and old conveyor belts in the first installment after making necessary payment and thereafter 9 installments. Then para 10, I am not disputing they have deposited 50,000 in security deposit. Para 10, may I read or I can
No,
say?
no.
Yeah. Para 11. That the plaintiff on different date deposited a total sum of rupees 60, 60 to 500. So this is the only amount deposited with us, not the entire contracted price.
No, there is no dispute on that.
There is
They
no
only
dispute.
know not
Kindly
at
come
all.
to Exhibit 2 clause of tender. जितना सामान उठाना चाहेंगे उतना पैसा जमा कर दीजिए, उतना का ही सामान मिलेगा. बाकी पैसा ये हमको देना चाहते हैं on which communication layer से. Kindly come to Exhibit 2 first, clause 10. It's an NIT, invitation to offer. It's not a contract. The ultimate contract is the terms and conditions decided. Exhibit 2. And today what they are claiming, something for which they have not performed their part within time. Exhibit 2, clause 10. It's very clear. Payment. The purchasers is PDF page here. It's PDF page 341 on the top probably written. You will see. On top 341 is written.
3-4.
Yes. This is Exhibit 2. This is instruction to tender terms and conditions. Kindly come to clause 10. The purchasers will lift the material in the installment after payment of sale value in full in cash. So what they were supposing? In cash at cash counter of all Bokaro Steel Plant or bank drawn on the State Bank of India, such and such city, within 10 working days commencing from the date of such and such. So what was the payment mode had they performed? The plaintiff nowhere says that they have deposited the entire sales considered. Then I will read paragraph 12 and 13. As per contract, इनको पूरा पैसा हमारे पास जमा करना था और उस पैसे की एवज में सामान सप्लाई होना था. Then ladies, if it is huge quantity, not possible to lift in one installment, we can give them installments. But पैसा तो एक ही बार में जमा होना था.
Which clause are you referring to?
Clause 10, ladies.
Clause 10 I've seen.
Yes.
In case of huge quantity.
Yes, next, in case of huge quantities, when it is not possible to lift, मतलब पूरा पैसा दे दिए एक बार में नहीं उठा सकते हैं. In one installment, the controller of state or stores or his representative may at his sole discretion allow materials to be lifted in more than one installments. मतलब हमको
Provided full cost of the material has been
yes.
deposited.
So it is unambiguous. So if they want that entire 714.800 metric ton was the contract entered between us, they should have first deposited the entire sales consideration of 714 metric ton. Now what they say in para 11 and 12 of that. जब आज के दिन में कोई कॉन्ट्रैक्ट ही सरवाइव नहीं करता और जो इन्होंने हमें 62,500 जमा किया, उसके बदले में इनको क्या मटेरियल मिला और कितना पैसा आउटस्टैंडिंग बच गया. दैट इज पैरा 11 and 12 ऑफ पेट. मे आई रीड दैट?
Yes, sir. Para 11 and 12.
11 of plate leadership. I don't have document, I have different thing.
Yes, please.
Yes, parallel. So it's also not disputed fact. The plaintiff on different date deposited a total sum of 500 by way of advance payment towards first, second installment of 50 metric ton, third, fourth installment of 75 metric ton towards lifting of material against the money receipts granted by the defendant. The details of installment payment is scheduled. So it is also an undisputed fact, only 16,62,500. Now, against advance payment of 16,52,500 for 250 metric ton. So this is the only concluded contract between us. I could have floated a tender for 1,000 metric ton. You could have been negotiated price with me. The term says कि सेल वैल्यू पूरा जमा करेंगे. सेल वैल्यू उन्होंने जितना जमा किया उतना का कॉन्ट्रैक्ट कंक्लूड हो गया. It is our fault we have not gone for any suit for damages or whatever. Now, so 52,520 for 250 metric ton of materials on, and the defendant supplied 219.350 metric ton of old used conveyor belts amounting to 1458,667 on various dates. So balance amount is 2,03,882. That's to be refunded by money suit. Thus, balance amount of such and such is lying deposit with the defendant towards cost of material against which delivery was not taken. Thus, out of total contracted amount of 740. Now, this is camouflage of drafting. This was never a contracted amount of quantity, out of which I have supplied 219, and today you are claiming 495. So you have paid for 250 metric ton. We have supplied 219.350 metric ton. The differential amount of advance was 2,03,822, stood refunded by the money suit. We complied that. Today what they are saying, anything which is recorded in that 1983 suit will give them fresh cause of action, and it is their brainchild that till the suit criminal case is pending, you have said that you will not supply. What is the evidence of that? Had we ever acknowledged or communicated anything with you? No. And what is the finding in the money suit? Their ladyship will find page 17 of the money decree, suit decree. The court has said that it cannot be an impediment. Since you filed a money suit, I can grant you only this much relief. If you want other relief, file a suit. Whether the relief granted 30 years back will give a cause of action today. Yes, I siphoned that amount. The relief has got time barred. Even if a wrong I have committed in 1983, somebody files a suit in 2015 and say that it's a time barred claim outrightly, which was taken care by the learned trial court. The relief, page 17, I will again read, although ladyship has already, they have pointed out. The court has also taken care that pendency of this case is cannot said to be justified, and therefore they can approach us. Yes, I have not approached us, but I have not acknowledged my. So, if you will keep sending us letter for another 100 years, the course of action will not get extended for another 100 years. If I will not choose
So
to,
the condition precedent for supply was deposit.
full value, I have read the clause 10, जितना का वो पैसा देंगे, rather contract का performance क्या था, पूरा 740 metric ton का पैसा देंगे. उसके बाद हम installment में या तो एक बार में उठाने के लिए बोलेंगे या हम पार्ट में उठाने के लिए बोलेंगे. इन्होंने पैसा तो पूरा कभी दिया ही नहीं था. पैसा प्लेंट में है कि 250 मीट्रिक टन का हम आपको दिए हैं, और उसमें से हमने 219 मीट्रिक टन सप्लाई कर दिया. 16 लाख में 14 लाख का इनको सामान मिल गया और 2 लाख रिफंड मिल गया. और सम रॉन्ग विच वाज कमिटेड इन द ईयर 1983 जो उनका रिफंड वापस नहीं हुआ, उसके लिए ये कॉज ऑफ एक्शन 2025 में नहीं हो सकता. दिस इज माय सजेशन. The page 17, if I will read again of the money suit, it has only says that the criminal case since disposed of, now you can get supply. Okay, I have accepted this. Where this money suit has कि that second and third case के disposal के बाद आपका cause of action आएगा, that is their own branch है. Is page 17 of the money suit judgment nowhere mentioned that till the second case is, rather the court is of the view that no, this cannot be a ground to stop your supply.
And the court has taken into consideration one of the criminal cases. The other criminal case was also pending on that date.
So where is the finding that till
and you accepted this judgment, so
yes.
they should have approached you according to you.
Yes. And if
that
they have,
you could have been aggrieved by the judgment of money
yes,
suit.
and we have complied. I cannot go beyond. We have complied. They have accepted. That is evidence that we have complied this judgment and decree, and it is to their satisfaction. I can read that paragraph.
So there is no doubt on that. They say that this amount has been paid.
So, ladyship, so far as second case pendency, that is their development of case. कि सेकंड केस चूंकि अगला 20 साल तक पेंडिंग रहा इसलिए इनका कॉज ऑफ एक्शन प्रिजर्व रह गया अगला 20 साल तक के लिए. इट्स नॉट अ जुडिशियल फाइंडिंग. And the entire finding with respect of the money suit is in context of the grievance raised before the court. And what was the prayer in money suit? Ladies, you can see what was the prayer. And then I will say prayer they have quoted in page 33, in para 20 of their play. That therefore the plaintiff was forced to file a money suit of 4583 against the defendant in the court of such and such, which was later on transferred to such and such, praying inter alia. Now, 1. The decree may be passed in favor of the plaintiff against the defendant for a sum of 390,332. This is the advance amount 2,30,000 जो उनको refund हो गया है on account of advance plus 50,000 on account of security deposit plus 136 on account of interest plus pending right interest, or in alternative a decree may be passed in favor of the plaintiff and against the defendant and directing the defendant to supply the balance quantity conveyor belts weighing such and such on taking balance amount from the plaintiff within a time to be fixed by this court, learned court, failing which to pay a sum of rupees such and such, such and such. So the court has said, I cannot grant, you can approach and you will have right. But how many days that right will preserve? For how many days that right will be, can be said to be preserved for them, for not for next 35, 40 years. The last payment, ladies, 2 dates, they will also not exclude. The last payment was made on 30th July 1980. The last supply or delivery was made to them. The last payment was made on 30th July 1980.
Yes, it is there.
And the last delivery taken by them is 6/8.
They want to keep the contract alive and they want material at the
And
cost
some
of 1980 date.
And some relief, even I have done wrong in 1980, I am not refunded, for which you are legally entitled. Today can this be granted to you? It has validated with passage of time. That is my humble notice. And then para 19 ladyship will see that what was their legal notice. They have said in para 19 of their complaint that what was the demand. This is the only legal notice.
This is 93.
Yes.
83, sorry.
Yes, 83. 16/7/1980. What they have demanded? That the plaintiff served a legal notice dated 16/7/1983. I am reading for a purpose, ladies, showing that you never wanted to perform contract. You wanted refund in 83. That the plaintiff served a legal notice dated 16/7/1983 to the defendant addressed to the managing director and Indian general manager materials Bokaro Steel Plant through his advocate inter alia demanding that either balance contracted material be supplied or the alternative sum of rupees such and such being security deposit be refunded along with interest these by. So what was your pair? Either to supply or to refund your money. And so far as existence of goods, leadership will see the exhibit 3. Items earmarked है, items specified है. Lot था, I can read that. Just after that, next page, what I have referred clause 10, leadership will see. ये ऐसा नहीं था कि जो निकलता रहेगा वो हम आपको बेचते रहेंगे. No. When the tender was invited, there is a list of unserviceable salvage materials for disposal through a tender number such and such. This was the earmark.
The quantity was also mentioned.
Yes. And kindly read paragraph 49 of the PW1. He has said कि उस पीरियड में सेल हमको नहीं देके किसी और को सामान बेच रहा था. Para 49 of the.
Yes, it has come.
Yes. So I was doing wrong at that time.
उसी समय था.
Yes, I was doing wrong at that time. You was, and by not approaching the court within reasonable time, you have lost your interest in the case. जो सामान earmarked है, ये relief आज नहीं हो सकता है कि today's whatever amount will come because it's an NIT.
Security का क्या करेंगे?
Security का हम दो reply देना चाहेंगे security के लिए. Whether this suit itself is maintainable or not. Leadership, I will apply one judgment on the Supreme Court. It's a suit for specific performance. Admittedly,
No, it is not a suit for specific performance. It is a suit for damages,
Yes.
refund, and specific performance.
It's leadership. ये हमेशा I will say suit either will be in general in nature. If leadership will be hearing it for 2 years. Declaration of right title interest is a general, it not under the provisions of any specific act. Claim of money is a general relief, not under any specific act. But the plaintiff, when approaches the suit, court under the provisions of a specific act, specific I mean to say, suppose Bihar Land Reforms Act. Suppose eviction of, JVCJ, earlier suit was made. Suppose under the provisions of specific relief act. Then also, in 1983, the court has said, I can only give you this part, but the refund is, can't be, it has to be in money claim. It has to be in compulsorily money claim, and why I am relying para 12 tradition will kindly see. Having noticed 3 judgments of this on court in Janki such and such, such and such, such and such, we are of the view in section of 12 of Specific Relief Act 1963, in a suit for a specific performance where the plaintiff is required to aver and prove that he has performed, so he has not performed, or has always been ready and willing to perform the essential terms of contract, a power of attorney holder is not entitled to depose in place and instead of plaintiff principal himself. In other words, if the power of attorney holder was rendered some acts in pursuance of power of attorney,
Here the power of attorney.
yes, plaintiff never come to the witness box. So how the court can ascertain the readiness and willingness by examining a third person who has a power of attorney holder, but he did not have the mental status of a similar person. Yes, I will read the entire. Yes. Essential
we have read it
term.
many times. We have read it many times.
Yes.
So many cases.
He requested to read the entire. Therefore, I said I
Just
can.
2-3 lines.
Yes.
Because
yes.
that is what the evidence is.
Yes. In other words, if the power of attorney holder has rendered some acts in pursuance of power of attorney, he may depose for the principal in respect of such acts. But he cannot depose for principal for the act done by the principal and not by him. Similarly, he cannot depose for the principal in respect of the matter of which only the principal could have personal knowledge and in respect of which principal is entitled to be cross-examined. If a plaintiff in a suit for a specific performance is required to prove that he was always ready and willing to perform his part of contract, it is necessary for him to step into the witness box and depose that the said fact and subject himself to cross-examine on that point. The plaintiff cannot examine in his place his attorney holder who did not have personal knowledge either of a transaction or his readiness and willingness. I will read the entire PW1's evidence. Where is readiness and willingness?
No, apart from this, that letter, that crucial letter which he says of 19, whatever, exhibit 10, right? Power of attorney is deposing that it was dispatched. That letter is not proved. That letter, that dispatch, he says that it was sent by registered post. Had the original plaintiff come, you could have cross-examined him on the point as to how it was dispatched, where is the receipt, or he could have given some explanation.
And my submission will be, even if that is considered, it is of which year? And if I have not performed,
20,
which year?
2010 letter is of
No.
which year?
They kept it sending.
No, that is the only letter.
No.
No, that is the only letter.
1993.
Yes, that is the only letter.
And
Thereafter, they have not sent any communication. Then they have a communication in 2015.
Yes. Yes.
These
So
are the two
10
letters.
to
Where is the power of attorney?
Was the exhibit 1.
Exhibit 1. Let's have a look at it. When was it executed?
The letter was of 1993, and if I have not responded in 1993, it doesn't mean I acknowledged it.
This is Manus 26.
Power of attorney is of 2016. So
2016.
So that is my case. That when how he can
You
say
cannot have any
that
personal
something
knowledge
which
of
has
any transaction.
He has deposed that specifically Manus the 2015 letter which were written for specific performance, those were written in his presence.
How does that
Exhibit
make
6
a
and
difference?
7.
How does that make a difference?
But the-
2015 letter is far reached.
but
First, the exhibit 10.
93 letter.
Yes.
Hold on, that is
and
He is
there-
nowhere in
and
1990.
therefore I have submitted that pursuant to this judgment something
He
which was
has-
done
no, he was there in
20
the 80 that 82 money suit also. He had deposed in 82 money suit also.
Suppose in what capacity?
As in plaintiff witness Manus.
Plaintiff witness, no. So, when he is pursuing a matter and as a power of attorney holder, so he has to behave like a power of attorney only. He himself, he has not deposed as witness in his individual capacity that every transaction had taken place in my presence. He cannot have both the role. That as a witness also he will appear and then as a power of attorney holder also he will appear because he is deposing on behalf of the plaintiff only. His every statement will be attributable to the plaintiff.
power of attorney cannot be retrospective. This is another limit of argument.
ये कहाँ ये
ये
बोल रहे हैं कि
2006 नहीं,
retrospective?
2016 के just a second 2016 के पावर ऑफ अटर्नी के बेसिस पे एक सूट फॉर स्पेसिफिक परफॉर्मेंस आता है जिसमें प्रिंसिपल का एक्ट which was done something in 1980
See,
that
I
cannot be said
just a moment. The whole principle of power of attorney is not that he should be the power of, that all the acts should take place after the execution of
no,
power.
I am not saying
That is not-
personal part
Yes, so personal part.
that is the distinguish created
That's
by the court personal part transactional part at best you can say this is the document yes I have dispatched it I am the only person sitting in this office I am handling everything so you can prove bills voucher but whether the Vipassana has the readiness and willingness another thing readiness means my personal readiness how the mental status of a power of attorney can show that number two willingness means it's a proprietorship concern but it's the financial statement of that plaintiff brought on record that I am capable and I was capable in 1980. This is the another argument, litigation. Willingness means right from the date of entering into contract till the relief granted by the court, they must be in a position to fulfill their obligation. There is no such incident. That for entire balance, entire contracted price, there is a bank account जिसमें मेरे पास पूरा पैसा था और वो पैसा आज भी intact है. That is not their case. and that is not the evidence available on record. The leadership, I will only say the section, what I will say that section 91 and 92, if leadership will see in the Evidence Act, his plaint is in derogation of section 91 of the Evidence Act, and therefore the amendment made in plaint. Why? Section 91 says that if there is a document entered in between the parties, that will be the primary evidence. 92 says any oral evidence contrary to that will not be obtained. So this is the clause 10 of a contract agreed between us and you. Any oral evidence कि आपने कहा था कि जब भी जरूरत होगा, ये शायद बीच से एक लाइन कैसे इनका केस फिर ये भी बनाने का, ये कस्टमरी प्रैक्टिस था. What is the evidence of that? ये जो बोल रहे हैं कि हम समय समय पे इनका एक एविडेंस में आएगा कि ये प्रैक्टिस था कि हम पैसा देते थे और आप हमको इंस्टॉलमेंट पे सामान उठाने देते थे, ये तो टर्म ही नहीं था. So
see, this would become very academic and it is not so straightforward. There could be terms and conditions in an agreement, numerous terms and conditions. Suppose there is a term and condition that the amount has to be paid through check.
Yes.
But the landlord continues to accept rent by cash.
Yes.
So there is a violation of terms and condition.
So the evidence will come in this regard.
So therefore,
Yes.
every written letter of the agreement is not,
But there is
something
no
which is
such
therefore this
Yes,
is a
yes,
grey
yes,
area
yes.
of interpretation.
Obviously.
अभी जो जजमेंट की इसी पे की है,
Yes.
अभी जो रिट में जजमेंट की.
I could not see that.
Conduct of the parties has a very strong bearing
Yes.
on the actual terms and conditions.
Yes. So
कभी
this.
कभी the terms and conditions remain a dead letter.
Yes. So, in my case, I can say this was a fixed terms and condition, but there was a deviation. Has to be pleaded,
That's right.
proved.
Certainly
So
that
that liability had been discharged in the plaint by a verdict that despite the reason clause 10 mandates deposit of entire sales consideration, but you have allowed by doing so, and then by evidence. No. That
How
is
many
not-
witnesses were examined?
Not two, one. And leadership.
Who was
will-
the second one?
Same person.
Same person. Why two witnesses?
Yes.
वो बाद में आए होंगे.
No.
Recall पर आए होंगे.
Bharat, that was for amendment.
Oh, post amendment.
Good leadership. PW1, Mr. Naresh Prasad Lodha was examined as PW1. Cross-examined, discharged. Thereafter, amendment application was filed on 30/8/2022, which was allowed. Then, in view of amendment, they filed a recall application that they want to recall their witness number 1, which was rejected by trial court on 7/11/2022. They come up before this honorable High
और
Court
ये
in CAP.
sequence.
They
When was he examined? Initially.
He was examined 25/3/2019, and ultimately he was discharged after closure of his evidence. He was discharged on 8/6/2022. Then amendment was proposed and allowed on 30/8/2022. After carrying out that amendment, they filed a recall petition on 7/11/2022 that since amendment is allowed, now witness has to be again called for proving certain documents that stood rejected by order dated 7/11/2022 itself. Then, on next day, 2/12/2022, they filed application that they want to move before this Honorable High Court in a civil revision application. Then they have moved. Then ultimately, order sheet shows that of 10/5/2023, the order sheet records that their CNP is allowed, CNP number 958 of 2022, and the PW1 is directed to be recalled. Pursuant there, this order of Honorable High Court, the again witness was recalled on 22/5/2023. He was examined and cross-examined. Same person, so there is two examination in chief, which has earlier created confusion for me also.
Second cross-examination is only with respect to the amendment.
Naturally.
Yes.
It has to be confined to him.
Yes. Therefore,
He was cross-examined earlier also.
yes, cross-examined earlier also, and in his cross-examination, if certain paragraphs I can say that para 39 is admission of lost day. अग्रिम जमा करने पे ही सामान लिफ्ट करने दिया जाता था. I will read only the.
That is not in dispute. So I also admit that.
Then the case is over.
No, but then that is intimation for payment of advance has to come. You never intimated. You suspended the deliveries.
Para 39. Old and used PW1.
आप इसको पढ़िए.
Yes.
पढ़ना तो हम लोग को तो लिखना ही पड़ेगा ना.
Leadership will.
You better read it.
Entire or 7-8
No,
paragraphs.
you read it entire.
Entire cross-examination.
पूरा पूरा
Yes, I get you.
क्योंकि हमको तो पढ़ना ही
Yes.
पड़ेगा. आप भी पढ़िए. एकदम तेजी से पढ़िए.
हिंदी कोशिश
हाँ.
कर रहे हैं. ठीक. मैं नरेश प्रसाद होता सच एंड सच. यह कि मैं वर्तमान वाद में वादी का अधिकृत मुख्तार हूँ, वाद तथ्यों से पूर्णतः अवगत हूँ. वादी ने मूल मुख्तारनामा 26/2016 की मूल प्रति दाखिल की है, जो कुल 4 पृष्ठों की है, जिसे मैं जानता हूँ. प्रदर्शन में अंकित किया जाए. यह कि वादी कैलाश कॉर्पोरेशन के नाम से अपना व्यापार संचालित करता है. यह कि प्रतिवादी कंपनी ने संदर्भ सच दिनांक सच 79 के माध्यम से कंपनी में इस्तेमाल किए हुए एवं अनुपयोगी सामानों के लिए टेंडर निकाला. वादी ने संदर्भ सच दिनांक 25/9/79 की मूल प्रति माननीय न्यायालय में दाखिल किया है. 4 पृष्ठों में है, जिसे मैं प्रदर्शन अंकित किया जाए. दैट इज द टर्म्स कंडीशन. यह कि वादी ने अपना टोटल कोटेशन 3,350 रुपीज प्रति मीट्रिक टन के दर से यूज कन्वेयर बेल्ट के लिए कुल 714.80 मीट्रिक टन के लिए जमा किया था. आवश्यक अग्रिम धन 30,000 दिनांक इसको जमा किया था. वादी ने कोटेशन दिनांक सच की छायाप्रति माननीय न्यायालय में दाखिल किया है, जो कि कुल 4 पृष्ठों में, जिसे मैं पहचानता हूँ. दिस इज एक्स मार्क फॉर आइडेंटिफिकेशन. Until date it is X marks, cannot be read as an evidence. That is my solution. It's marked for identification. यह कि उपरोक्त यूज और ओल्ड कन्वेयर बेल्ट का असॉर्टेड साइज के अलावा वादी के 4 अतिरिक्त पक्षकारों ने भाग लिया, परंतु वादी का दस्तावेज वैध था. यह कि प्रतिवादी कंपनी को वादी द्वारा दिए गए दर सच प्रति टन स्वीकार्य नहीं था. अतः प्रतिवादी कंपनी ने वादी एवं अन्य पक्षकारों के साथ वार्ता दिनांक सच 1980 को रखा, जिस पर बातचीत के पश्चात 6,650 रुपये प्रति मीट्रिक के दर से भुगतान को सहमत हुआ और अग्रिम राशि के रूप में 20,000 रुपये का भुगतान किया गया. वादी ने अपने रिवाइज कोटेशन सच तथा पत्र दिनांक सच की मूल कार्यालय प्रति माननीय न्यायालय में दाखिल किया, जिसे मैं पहचानता हूँ. कुल 2 पृष्ठों में है. 3 and X/1. यह कि प्रतिवादी कंपनी ने वादी के रिवाइज कोटेशन के आधार पर मिनट्स ऑफ मीटिंग दिनांक सच तैयार किया. वादी ने मिनट्स ऑफ मीटिंग दिनांक सच की छायाप्रति माननीय न्यायालय में दाखिल किया, जो 3 पृष्ठों में है, जिसे मैं पहचान X/2 अंकित करता हूँ. दिस इज ऑल्सो मार्क फॉर आइडेंटिफिकेशन. यह कि प्रतिवादी कंपनी ने अपना पत्र संदर्भ सच 1980 के माध्यम से वादी के रिवाइज कोटेशन को स्वीकार कर की सूचना वादी को दी, जिसके आधार पर वादी को कुल 10 किस्तों में माल उठाव का आदेश मिला था. वादी ने पत्र संदर्भ संख्या सच की छाया प्रति, जो 1 पृष्ठ में है, माननीय न्यायालय में दाखिल किया, जिसे मैं पहचानता हूँ. दिस इज ऑल्सो X3 आइडेंटिफिकेशन नॉट प्रूव्ड और टेकन ऑन रिकॉर्ड. यह कि वादी ने अग्रिम राशि सिक्योरिटी डिपॉजिट के रूप में 30,000 और सच को 20,000 रुपये प्रतिवादी कंपनी में जमा किया. यह कि वादी ने विभिन्न तिथियों में कुल 16,62,500 रुपया अग्रिम भुगतान के रूप में प्रथम एवं द्वितीय किस्त 50-50 मीट्रिक टन एवं चौथे किस्त 75 मीट्रिक टन के उठाव हेतु प्रतिवादी कंपनी में जमा किया था. यह कि वादी ने 250 मीट्रिक टन यूज गोल्ड कन्वेयर बेल्ट्स आपके उठाव के लिए 1650 to 500 रुपीस जमा करने के बाद भी प्रतिवादी कंपनी ने केवल 14,677 मूल्य का कुल 19.350 मीट्रिक टन यूज्ड एंड ओल्ड कन्वेयर बेल्ट्स ऑफ असॉर्टेड साइज की सप्लाई वादी को किया। प्रतिवादी ने वादी को एमपी स्टोर कंस्ट्रक्शन यार्ड के अलावा अन्य शॉप और कोक ओवन ब्लास्ट फर्नेस आदि से माल की आपूर्ति की। यह कि प्रतिवादी कंपनी ने संविदा के तहत कुल 714.800 मीट्रिक टन के बदले केवल 219.350 मीट्रिक टन का सप्लाई वादी को किया और शेष 495.450 मीट्रिक टन प्रतिवादी कंपनी के पास ही रहा। साथ ही वादी का जमा किया हुआ अग्रिम राशि 1652 में से 2,03,882 रुपए भी प्रतिवादी कंपनी अपने पास रख लिया। यह कि वादी ने प्रतिवादी कंपनी के अग्रिम भुगतान 1980 के को किया था और वादी प्रतिवादी कंपनी द्वारा अंतिम बार माल का उठाव 16 फ्रॉम देयर ईयर से लास्ट सप्लाई एंड लास्ट पेमेंट 6/9/1980। या कि वादी द्वारा चौथे किस्त के यूज कन्वेयर बेल्ट के उठाव के दौरान ही वादी के ऊपर मारामारी कांड संख्या 7 दर्ज हो गया, जिसके आधार पर प्रतिवादी कंपनी ने वादी को माल उठाव से रोक दिया। या कि वादी के साथ प्रतिवादी कंपनी के अधिकारियों के साथ प्रतिवादी कंपनी के अधिकारियों पर भी पूरक मुकदमे के अतिरिक्त मारामारी कांड संख्या 7 दर्ज हुआ। यह कि अपराधी मुकदमा लंबित रहने के दौरान वादी ने निरंतर कंपनी में शेष 495.450 मीट्रिक टन का उठाव करने का अनुरोध किया, किंतु प्रतिवादी कंपनी ने वादी को शेष माल उठाव करने के बजाय नया टेंडर ऑप्शन निकालकर वादी के अतिरिक्त अन्य पक्षकारों को माल उठाने दिया। So kindly mark that in which year I have sold their as per their items.
Para number, just para number.
Para number 16. वादी ने अपने पत्र दिनांक 5/6/1982 की छाया प्रति माननीय न्यायालय में दाखिल किया है। सो मैंने इनका सामान इनको नहीं देके किसी और को बेच दिया और इसके लिए हमने नया टेंडर में निकाल दिया, परंतु प्रतिवादी कंपनी ने सेल्स माल का उठाव करने देने के बजाय नया टेंडर ऑप्शन निकालकर वादी एवं अन्य पक्षकारों को माल उठाने दिया। तो हमने किसी और को माल उठा दिया और इसका कंप्लेन इन्होंने अपने लेटर में 82 में किया। नाउ यह कि अनुसंधान के पश्चात अनुसंधानकर्ता ने मारामारी कांड संख्या सच में तथ्य की भूल दर्शाते हुए दाखिल किया। वादी ने मारामारी कांड संख्या सच की अभिप्रामाणिक प्रति छाया प्रति न्यायालय में दाखिल किया, जिसे मैं पहचानता हूँ X/5। यह कि वादी ने अपने विधिक नोटिस 16/7/1983 दिस इज आई रेफर पैरा 19 ऑफ प्ले के माध्यम से प्रतिवादीगण से अनुरोध किया या तो प्रतिवादी को 499.50 मीट्रिक टन का उठाव करने दें या नहीं तो शेष अग्रिम राशि 2,03,822 और 50,000 रुपीस का सिक्योरिटी डिपॉजिट 22/7/83 तक ब्याज सहित लौटा दें। दिस इज पैरा 19 ऑफ प्लेट। सो दिस वाज द डिमांड
Which he has stated in para 18.
Yes, in plate I have read that.
In
para
this-
19 sorry.
यहाँ पे तो para 18.
यहाँ para 18 प्लेट का para 19. This is the legal notice 16/7/1983. So what was the demand? या तो सामान दें या मेरा पैसा और सिक्योरिटी लौटा। एडवांस तो लौटा दिया। कोर्ट ने कहा कि आप चाहें तो हमको अप्रोच करिए क्योंकि आपका कारण गलत है, हमारा कारण गलत है। इन्होंने नहीं किया अप्रोच और हमने सिक्योरिटी नहीं लौटाया। नेक्स्ट, या कि वादी मजबूर होकर धनवाद संख्या 45/1983 माननीय न्यायालय में दाखिल किया, स्थानांतरित हुआ। या कि प्रतिवादीगण धनवाद संख्या में उपस्थित होकर लिखित कथन दिनांक इतना को दाखिल किया। लिखित बहस भी माननीय न्यायालय में दाखिल किया। वादी ने लिखित कथन सच की छाया प्रति और लिखित बहस की छाया प्रति न्यायालय में दाखिल की है। इसे X/6 एंड डैश अंकित करें। सो माय सबमिशन today in this venue of appeal there is a written notes of argument which was never brought on record. From there I can say. And so far as written statement today, what they are arguing, it's marked for identification. So that is equally not on record. Para 20. इन्होंने कहा कि मैंने वहां अपीयर करके रिटन स्टेटमेंट दिया और लिखित बहस दाखिल किया। मेरा रिटन स्टेटमेंट X/6 बना, not formally proved as before the trial court, could not be taken into consideration. And लिखित बहस डैश अंकित करें। Written notes today here is filed. There was not there. So these two documents are in here. Then para 21. या कि प्रतिवादीगण ने अपने लिखित फ्रॉम देयर नाउ मेकिंग अपने लिखित कथन और लिखित बयान में स्पष्ट रूप से कहा है कि कॉन्ट्रैक्ट इज सब्सिस्टिंग एंड इन व्यू ऑफ क्रिमिनल केस ओनली डिलीवरी ऑफ मटेरियल हैज बीन सस्पेंडेड. सो दिस इज देयर इंटरप्रिटेशन that since I said in written statement and written argument, none of them is on record, I can say. Neither the written statement nor the written argument is a part of record before this honorable court and can be taken into account to say that contract is subsisting, which is admission by me. And ladyship, in this context, ladyship, I see section 58 of Evidence Act. Admission only in that proceeding is binding. If ladyship will see for a moment that section 58 of Evidence Act, it says any admission made in that particular proceeding will be binding. It's not that I have said something in
That
some.
may not be relevant.
दे यह कि माननीय सब जज न्यायालय सब्जेक्ट सच एंड सच में दोनों पक्षकारों के साक्ष्य दस्तावेजों के आधार पर दिनांक सच एंड सच को वादी के पक्ष में निर्णय पारित किया गया. प्रतिवादी कंपनी को जमा रकम 2,03,822 12% ब्याज के साथ भुगतान की तिथि तक भुगतान करने का निर्देश दिया और वादी को छूट दिया गया कि बकाया यूज और कन्वेयर बेल्ट असॉर्टेड साइज के उठाव हेतु वादी से अलग वाद पर दायर करें. साथ ही न्यायालय में यह निर्णय किया गया कि वादी और प्रतिवादी के बीच संविदा अभी जारी है. वादी ने माननीय सब जज बोकारो पारित आदेश सच एंड सच को प्रदर्श 4 अंकित करें. सो दैट इज देयर अंडरस्टैंडिंग, इट विल कीप डूइंग. प्रतिवादी ने माननीय कंपनी न्यायालय पैरा 23 आई कंप्लाइंट. प्रतिवादी कंपनी ने माननीय न्यायालय सब जज बोकारो नाची के निर्णय के अनुरूप वादी को अग्रिम राशि सच एंड सच को वादी को लौटा दिया, परंतु वादी द्वारा सिक्योरिटी डिपॉजिट में किया 50,000 अपने पास रखा जो अब तक प्रतिवादी के पास जमा है. सो दैट वाज आल्सो 1982-83. यह कि वादी और प्रतिवादी के कंपनी के अधिकारियों के विरुद्ध मारामारी कांड संख्या सच एंड सच में वादी के द्वारा सभी अभियुक्तों को वादी सहित सभी अभियुक्तों को बरी कर दिया गया. थाना कांड संख्या सच एंड सच को प्रदर्श अंकित करें. यह कि वादी ने उपरोक्त मुकदमे में बरी होने की सूचना सच एंड सच लेटर 99/2015 फ्रेश कॉज ऑफ एक्शन एज पर डेट प्रतिवादी को दिया. वादी के पत्र दिनांक सच एंड सच की मूल प्रति
6 and 651 क्या है?
एवं मूल रिसीव्ड, बट दैट इज 651. अच्छा, yes, it is there. The chart also says postal receipt dated 9/9/2015.
2000?
9/9/2015.
9/9/2015.
Exhibit 6/1. It says judgment also.
Okay, this is about the new legal notice, not about the previous letter.
No,
Exhibit
no,
10
no.
का कहानी नहीं
ये
है.
2015 में कि चूंकि अब हम दूसरे केस में भी
That's
बरी
right.
हो गए.
That's right. That I got.
Yes.
ठीक.
Just
इसमें कहाँ ये बोले हैं कि the intimation used to come from the company कि इतना पैसा जमा करा दीजिए and तब इनको जमा कराना.
कहीं नहीं है. This is my case.
From where do you get this?
They had suspended the delivery since 1980. Their condition was we will not deliver you till the criminal case is over. Because we kindly see Exhibit 7.
Exhibit से नहीं होता, आप evidence में दिखाइए. कि as per the procedure, evidence दिखाइए. ये
The procedure तो ये मतलब पैसा तो हम तब जमा करेंगे ना when they are willing to deliver. They said that we will deliver only once the criminal case is over. So once the criminal case was over, we wrote to them that
if
we are
that
ready
be
with
so,
the, we
if
are
that
ready
be
with
so,
the money.
if that be so, there was no occasion for the earlier round of litigation to ask you to approach them. But you see, if there was a criminal case, if the criminal case that you are referring to was also existing in the suit,
Yes, Yes, it was
right?
interesting while
But
the-
in spite of that, a direction was given that you could approach them for the balance quantity, right? And the court said that irrespective of criminal cases, the court mentioned about one criminal case, did not mention about
Say
another
about
criminal
this.
case, did not mention about other criminal case. We will not read anything into it, right? The court said that whatever it is, you can approach them. Now, on the basis of another criminal case which remained pending even at the time of money suit, wherein there was an order of acquittal or what closure in the year 2015, how do you pick up that as a cause of action? Your entire cause of action is because of the order passed in money suit.
Money suit, after money suit, there were subsequent developments. They maintained the stand that
From
they
where
will-
do we get this?
Because that is also there in our Exhibit 7, wherein we say in categorical terms that you all the while have maintained the stand that after disposal of the second criminal case, you will give us the delivery.
So
They
if-
never objected
just
to
a
this
moment.
letter also.
If that be so, then what is the big idea of going for money suit and getting a direction from money suit?
Money suit, we had gone for refund of the advance money which was lying with them. They refunded the advance money because they said that we can't retain this money because we are not supplying to you as of now. We will take the advance money only when we are ready to supply. Why did they refund our advance money? They should have challenged the order. The very reason they refunded our advance money was the reason that they were not in a position to supply. And they said that we will supply once the criminal case is over.
There is no such.
And then in
There is
Exhibit
no such
7,
finding.
there is no.
no, there is a categorical statement in the written statement.
That will not, we are not.
May I
going to
further
read it.
conclude?
That what, and it has been recorded in the judgment. And therefore, thereafter, Manoj, in Exhibit 7, we state the same thing. And Exhibit 7 has never been objected or disputed.
Exhibit 7 is what?
Exhibit 7 is our letter. Manoj, may I please that letter? It records all the facts. They never objected to it. And Exhibit 7 is along with the postal
May
receipts.
I read
This is 2015 again.
Manoj, it is 2015, but it narrates the entire facts. What had happened till 2015. And they have never disputed this
Is that,
letter.
how will they dispute the contents of this letter unless Mr. Prem Kumar comes in the dock?
Exhibit 6 and 7 postal receipts are there. They have received
You
it.
see, the contents of it is two different things altogether. Proving the contents of a letter and proving the letter are two different things.
I do.
So you
I
say
do-
that so many things have been mentioned.
Manoj,
Had Mr. Prem Kumar come
Manoj,
in the witness box, he could have been examined on many aspects of the
Manoj,
matter.
PW1 categorically PW1 was cross-examined that whether this letter was written in your presence. PW1 categorically says yes, these letters were made in my presence.
Even if the letter is written in my presence, but the contents of the letter are relating back to past events.
They are, Manoj.
Then
But
under
they-
suppose I write a letter that I have murdered somebody, right? Maybe it is written in my presence, but the incident is relating to a previous point of time.
It is.
There are so many incidents which are relating to previous point of time.
It is indeed, Manoj. But then once they had received this letter, they could have objected to the contents. They never objected to the contents. And
You
all the
have to
while,
prove your own case, no?
I have to, Manoj. Indeed, I have to. But they also have to raise some objection. Once I have proved that I have dispatched this letter, the contents of the letters are there on record. It was their duty to at least give some objection to that letter that the contents which you are mentioning are wrong. They could have said so in the WS. They never filed WS. They never objected to this letter.
Para 26.
Yes, please.
I will respond to this part of our argument. यह कि वादी ने पुनः अपने पत्र दिनांक 89/2015 के द्वारा प्रतिवादी कंपनी को शेष 49.540 मीट्रिक टन का उठाव का अनुमति मांगा। साथ ही अपने उपरोक्त पत्र में वादी ने यह भी लिखा कि बकाया राशि के भुगतान करने को तैयार है। So this is first line after 1983 that they are ready and willing. इससे पहले जो 25 पैराग्राफ्स लिखे हैं, there was neither the readiness nor the willingness. This is first line कि मैं बकाया राशि की भुगतान करने को तैयार हूँ in 2015 for 1980 contract. तैयार हूं। प्रतिवादी से गण से अनुरोध किया। प्रतिवादी कंपनी ने अपने लेखा विभाग को वादी से राशि प्राप्त कर संदर्भ पत्र सच एंड सच 25 for 1980 के आधार पर निर्गत करे। वादी ने पत्र संदर्भ सच एंड सच की मूल प्रति, सच एंड सच की मूल प्रति एवं मूल मनी रिसीट रजिस्ट्री रिसीट माननीय न्यायालय में दाखिल किया, जिसे मैं पहचानता हूँ। इसे ब्रदर सच एंड सच का अंकित करें। So prior to this 18/9/2015, where is the readiness and where is the willingness? That's why I said it's a suit for a specific performance. 1980-82 I have committed wrong, but till 2015 there is no readiness on your part. अपने बकाए, because section 16C is the with C of specific relief act, that the plaintiff has performed his part of obligation. There are two lines. Plaintiff has performed his part of obligation and he is all along ready and willing.
Where is the statement that after the money suit in the year 1983, the defendant had stated that till the criminal case is disposed of, there will be no supply in his evidence.
In his evidence that up to here no.
ऐसा तो कोई
Up to
statement
here
नहीं.
no. Up to here no.
You see, para 22 says that पक्ष में निर्णय किया. Right? Para 22 exhibit 4 हो गया.
Yes.
उसके बाद का statement आता है.
नहीं, उसके बाद कुछ भी नहीं है.
कुछ भी
मैंने
नहीं है
पैसा
उसके
वापस
बाद.
किया. Therefore I am
उसके
saying
बाद
suddenly
there is nothing mentioned as to what happened in between.
Yes.
And although it is mentioned in this letter.
Yes.
In this letter you see exhibit number is exhibit 7.
7 they say.
Exhibit 7, you see
yes.
he is mentioning so many things.
Yes. So
that thereafter delivery of balance was stopped and suspended after initiation of police case. All our written and oral requests to deliver the balance material was in vain, right? Then they talk about this mistake of fact. Then recently they say that
he is acquitted.
it is ended in acquittal,
Yes.
right?
And in the meantime, undersigned all
Where is
along.
it? Where is it? They say that even after disposal of the criminal case,
or liberty granted by money suit,
By money
they
suit,
approached me.
they approached me and we said that
We will not supply till the
It is
criminal
not
case
there
is
in this letter. Kindly read it. Read it from your evidence, not from this letter. Letter does not form a part of anything. Read it from your evidence that what steps have you taken after the disposal of the money suit.
मतलब पैरा 8
Para 8 नहीं evidence. आपका oral evidence पढ़िए.
oral evidence मतलब
Para 22. Para 22 is the money suit. Read further.
Yes, para 22 is money suit exhibit is there.
उसके बाद बताएंगे.
23 that I have refunded. Then 24 they say they are acquitted in 2015.
Yes.
So 92 to 2015 nothing happened.
अब हमको बताइए. Please एक second. Please in the corner. Please ऐसे नहीं करना. I'm looking at it.
मतलब in para 23 he says मतलब में यह कि प्रतिवादी कंपनी ने माननीय न्यायालय सब्जेक्ट युक्त बुकारों के निर्णय के अनुरूप वादी की अग्रिम राशि ₹2,03,822 को वादी को लौटा दिया, परंतु वादी द्वारा सिक्योरिटी डिपॉजिट के रूप में जमा किए गए ₹50 को अपने पास रखा, जो अभी तक प्रतिवादी कंपनी के पास ही जमा है। यह कि वादी एवं प्रतिवादी कंपनी के अधिकारियों के विरुद्ध दर्ज माराफाड़ी थाना कांड संख्या 100 में माननीय विशेष निगरानी न्यायालय धनबाद में अपने निर्णय दिनांक 13/3/15 के द्वारा वादी सहित सभी अभियुक्तों को बरी कर दिया। वादी ने माराफाड़ी थाना कांड संख्या 15 में पारित निर्णय दिनांक 13/3/15 को प्रमाणित प्रति माननीय न्यायालय में दाखिल किया, जिसे मैं पहचानता हूँ, जिसे प्रदर 5 अंकित किया गया। यह कि वादी ने उपरोक्त मुकदमे में बरी होने की सूचना पत्र दिनांक 9/9/15 के द्वारा प्रतिवादी कंपनी को दिया। वादी के पत्र दिनांक 9/9/15 की मूल्य प्रति एवं मूल्य पोस्टल रिसीट माननीय न्यायालय में दाखिल किया, जिसे मैं पहचानता हूँ। इसे क्रमांक संख्या 6 एवं 6(1) अंकित किया जाए। यह कि वादी ने पुनः अपने पत्र दिनांक 18/9/15 के द्वारा प्रतिवादी कंपनी से शेष मीट्रिक टन के उठाव की अनुमति मांगी। साथ ही अपने उपरोक्त पत्र में वादी ने यह भी स्पष्ट रूप से लिखा कि वादी बकाया राशि का भुगतान करने को तैयार है और प्रतिवादी कंपनी से अनुरोध किया कि प्रतिवादी कंपनी अपने लेखा विभाग को वादी के राशि प्राप्त करने संबंधित पत्र संदर्भ संख्या सो के आधार पर निर्गत करे। वादी ने पत्र संख्या दिनांक 25 अप्रैल 1980 की मूल प्रति, पत्र दिनांक 22/4/1980 एवं पत्र दिनांक 18/9/15 की मूल प्रति कार्यालय की
You see, it is not there in your evidence. What did you do after 1992? It is completely silent. You have not proved that after 1992 you ever approached him for anything. That is not your case. Nor even in your letter you do not say anything that you approached them after 1992.
Para 8. That I was reading.
Para 8 of?
Para 8 of this exhibit 7. That letter says so.
That
all.
Let me just assume for a moment that letter says so. Where is the evidence? That letter will not form a part of the evidence. You have to say what you did after 1992. ये read petition में नहीं है ना, यहाँ पे सब चीज बोलना पड़ता है, सूट में सब चीज बोलना पड़ता है, नाम से लेकर उम्र तक.
Since the document records it, the document has been.
ये commercial appeal, commercial suit नहीं है. Commercial suit is almost like a writ petition. Sometimes I feel a commercial suit is almost like a writ petition.
This is a commercial suit, that is our contention, first contention. Para 8 में record करते हैं that all our written and oral requests to deliver the balance materials were not heeded on the pretext that delivery could not be resumed till the disposal of criminal cases.
एक सेकंड, ये जो चीज है ना para 8, it was in the exclusive knowledge of the plaintiff, not in the knowledge of the power of the plaintiff. That is why he has not deposed anything on that. This particular person was very much conscious of the fact कि ऐसा कोई deposition हम नहीं कर सकते. He is very conscious of this fact. इसीलिए evidence on affidavit में जो वकील साहब ने बनाया है, he is also conscious of this fact that this power of attorney will not be in a position to depose as to what happened from 1992 till 2015. Otherwise उसका evidence ही खत्म हो जाएगा. इसीलिए बोलते हैं पूरा evidence पढ़ने से सब clear होता है. There is no evidence.
But at the same time, this is also a fact that they never terminated the contract. Contract, in fact, even today is subsisting. They never terminated. They deliberately, and the finding in the money suit was that contract is subsisting and valid.
वो civil death सुने है ना? इससे contract का भी civil death हो गया.
They never. They never.
तो 50,000 रुपए क्यों नहीं वापस करते हैं भाई?
They should have refunded. They should have
वो भी
refunded
नहीं
in the
करेंगे.
first round itself.
Yes. Instruction क्या है? कि भले हार जाइए लेकिन refund नहीं करना 50,000.
50,000 उसी first round में refund कर देते.
नहीं, wrong was committed. But
no, wrong was not committed. You deliberately took the stand that we will supply once the contract, once the criminal case is over.
Can I finish that? Then I will say about that. Para 27, वादी के पत्र का कोई जवाब प्रतिवादी के द्वारा नहीं दिया गया. No acknowledgement by us. Use conveyor belt के उठाव में. Next again, para 28. Now they say used an old conveyor belt of assorted size वर्तमान में नियमित रूप से प्रतिवादी कंपनी द्वारा खरीदारों को उठाव बेचाव किया जाता है. मतलब now he is claiming from new lot. Earlier he said his lot is sold, already sold. Now he says still since you are selling, so from new lot he wants. यह कि वादी प्रतिवादी कंपनी के बीच निविदा संदर्भ सच के दिनांक 1979 तथा उपरोक्त निविदा आधार पर संविदा दोनों पक्षकारों के बीच अभी भी जारी है और वादी से 49.45 मीट्रिक टन का हकदार है. उठाव का दर 6650 प्रति मीट्रिक दर से करने के हकदार है. सुवादी ने सही पाया. नाउ लीडरशिप विल सी द क्रॉस एग्जामिनेशन. अगेन 30-40 पैराग्राफ्स। वादी ने मनी सूट 4583 का डिग्री की प्रमाणित प्रतिलिपि माननीय न्यायालय में दाखिल किया है। इसे 4/1 वादी द्वारा सेल बोकारो को लिखे गए 1980 की मूल प्रति दाखिल किया, जिसे मैं पहचानता हूँ। मैनेजर शिवशंकर अग्रवाल का हस्ताक्षर है। इसे ब्रदर्स 9 अंकित किया जाए। सो सन ब्रदर्स 9 1983 it was marked exhibit. Then कैलाश कॉर्पोरेशन प्रोपराइटर से फर्म है, इसके प्रोपराइटर प्रेम कुमार है। अभी टैक्सेबल इनकम नहीं है, इसलिए इनकम टैक्स रिटर्न फाइल नहीं करते। Now kindly mark this one. He has got no taxable income. And what is the quantity? And what is the price he wants? जो अभी 495 इन मीट्रिक टन का इन्हीं के रेट से हमको जो सप्लाई करना है, इट मस्ट गो बियॉन्ड 15-20 लाख, क्योंकि हमने इनको 215 मीट्रिक टन के लिए चार्ज किया था 16,62,000। बैलेंस ये मानते हैं ट्वाइस 32 लाख शॉर्ट का अमाउंट है, एंड ही इज नॉट इनकम टैक्स एसएससी। पैरा 34 एम आई क्लियर? 214 मीट्रिक टन का उस वक्त सेम रेट से 16 लाख था, और बैलेंस क्वांटिटी है 495 मीट्रिक टन, तो डबल द क्वांटिटी 32 लाख का है। ये इनकम टैक्स एसएससी आज नहीं,
इससे कोई मतलब नहीं है।
ठीक, बट ही हैज नो पेइंग कैपेसिटी, he has got no, it's a suit for specific relief act, he must be in a position to pay 32 lakhs। और अगर उधार लेके देंगे तो एविडेंस लाना होगा कि मेरी कैपेसिटी नहीं है, माय फ्रेंड इज ऑलरेडी रेडी टू गिव मी सम लोन, बोरोइंग इज रेडी एंड फ्रॉम देयर आई विल पे। once he says that अभी taxable income नहीं है इसलिए इनकम टैक्स रिटर्न नहीं फाइल करते, he is not in a position to perform contract of 32 lakhs।
I might have savings of more than that. I don't have the
But where is the
I
evidence?
might have.
May I finish, sir? Side by side मत करिए। My submission is para 34 is contrary to the judgments of Honorable Supreme Court, which says that plaintiff has to all along ready. If says I don't have money, I am not an income tax assessee, clear mathematical calculation shows that payment of 32 lakhs have to be made. Where is the evidence he will borrow from relative and saving? I will read entire. मुझे जानकारी नहीं है कि कैलाश कॉर्पोरेशन कब अंतिम बार टैक्स फाइल किया था, सो ही का प्लेंटिफ हैज नॉट का, हम और प्रोसेस नहीं कर सकते। कैलाश कॉर्पोरेशन के व्यवसायिक कार्यों के बारे में मुझे व्यक्तिगत जानकारी है। नेक्स्ट, जब टेंडर कार्यादेश के लिए बोकारो इस्पात में दाखिल किया गया था, उस समय मैं बोकारो में था। मैं कैलाश कॉर्पोरेशन के व्यवसायिक बारों में सुनकर जानता हूं, क्योंकि उसके मालिक प्रेम कुमार मेरे मामा लगते हैं। पैरा 38। Now I will refer to para 12 of that judgment, if ladyship will permit, that a power of attorney holder can come and say only with respect of the works something which was done by him or
That's right.
in continuation of business transaction, but readiness mailingness is not a business transaction, it's a mental status। मैं कला व्यवसायिक बारे में सुनकर जानता हूं, क्योंकि उसके मालिक मेरे मामा लगते हैं। ओल्ड यूज कन्वेयर बेल्ट के लिए कैलाश कॉर्पोरेशन को किस्तों में अग्रिम भुगतान करना पड़ता था। इसके पश्चात उस भुगतान के पश्चात ही बराबर माल उठा सकते थे। Para 39. So unless payment is come, we will not allow any lifting, and it's not a contrary to clause 10 of Exhibit 2। पैसा जमा करेंगे तो, और पैसा जमा करने का तो कोई एविडेंस नहीं है। मुझे इस बात की जानकारी नहीं है कि जिस पीरियड में कॉन्ट्रैक्ट हुआ था ओल्ड यूज इस्पात संयंत्र में अभी मौजूद होगा। गवाह पुनः कहते हैं होना चाहिए। ओल्ड यूज कन्वेयर बेल्ट आइडेंटिफिकेशन के लिए कोई मार्क नहीं लगा हुआ रहता था। मैं MS मनी सूट 4583 का वाद पत्र न्यायालय में दाखिल नहीं किया हूँ। मनी सूट 4583 में मैं सेल बोकारो स्टील के विरुद्ध बकाया माल के अलावा अग्रिम राशि जो जमा है उसकी वापसी के लिए वाद लाया था, जो है MS मनी सूट 45 1983 में मैं बोकारो प्लांट के द्वारा कहा था कि अग्रिम बकाया राशि नहीं देंगे, क्योंकि यह आपराधिक मामला है। गवाह को बोकारो स्टील के लिखित बयान जो कि सच एंड सच में दायर किया गया था, ध्यान आकृष्ट करने पे गवाह कहते हैं, लिखित बयान में यह नहीं लिखा गया है कि आपराधिक मुकदमे रहते कार्यादेश में वर्णित ओल्ड स्क्रैप्ड बेल्ट को वादी को नहीं दिया जाएगा. So why it was marked X6, identification X6? Because this was the statement. ऐसा मेरा कहीं स्टेटमेंट नहीं है कि हम नहीं देंगे. कैलाश कॉर्पोरेशन के द्वारा बोकारो इस्पात संयंत्र द्वारा माल की आपूर्ति नहीं करने पर हम लोगों ने संविदा को रद्द नहीं किया. कैलाश कॉर्पोरेशन अंतिम बार 6/8/1980 को माल उठाए थे. 1982 में कैलाश कॉर्पोरेशन ने बोकारो इस्पात संयंत्र में माल की आपूर्ति हेतु पत्र लिखा था. यह पत्र न्यायालय में दाखिल किया. यह बात सही है कि इस पत्र के माध्यम से हम लोग बोकारो पत्र को बताए थे कि हम लोग को जानकारी मिली है कि जो माल हम लोग को मिलना था उसका फ्रेक्स ऑप्शन किया जा रहा है और शेड्यूल सक्सेसफुल बिडर उन कन्वेयर बेल्ट को उठा रहे हैं. दैट आई एम रेफरिंग. एंड फ्रॉम व्हिच ईयर? 1982. इनका सामान हम किसी और को दे रहे हैं और वो फ्रेश ऑप्शन में वो सामान उठा रहे हैं. So that was the cause of action. इनका सामान जब जा रहा था. सन 1982 के बाद हम लोगों ने कोई पत्र बोकारो संयंत्र को माल देने हेतु लिखा था, लेकिन उन पत्रों को मैं न्यायालय में दाखिल नहीं किए. गवाह कहते हैं खोज कर न्यायालय में जमा कर सकते हैं. मैं अगली तिथि को 1-2 पत्र न्यायालय में दाखिल कर देंगे. मुझे याद नहीं है कि मनीसूट 4583 में उन पत्रों का जिक्र किया गया है. ऐसी बात नहीं है कि मनीसूट 4583 में कैलाश कॉर्पोरेशन अपना पैसा वापस पाने हेतु दायर किए, बल्कि माल आपूर्ति के लिए दायर किया है. मैं लिखित बहस में जो बोकारो इस्पात संयंत्र का न्यायालय में दाखिल किया उसमें ना तो किसी अधिवक्ता का हस्ताक्षर है, ना ही बोकारो इस्पात संयंत्र के किसी सक्षम पदाधिकारी का हस्ताक्षर है. If litigation will mark that it is not a rule of pleading, any unsigned document by the defendant is not binding. Para 54. So they rely on two things: written statement and written notes of argument. Written statement never brought on record, and written argument doesn't contain my signature or the company's signature. मैं MS 145(3) में भी अपना गवाही दिए थे. कैलाश कॉर्पोरेशन के विरुद्ध आरोप लगाया गया था पुराने बेल्ट के बदले अच्छे बेल्ट लगवाते थे. हमारा थाना कांड संख्या 1980 में हुआ था जिसमें यह आरोप लगाया गया था बोकारो इस्पात संयंत्र कैलाश कॉर्पोरेशन को टेंडर स्वीकृत करने में पक्षपात किया है. कैलाश कॉर्पोरेशन को बोकारो इस्पात संयंत्र द्वारा 4583 में न्यायालय आदेश अनुसार बचे हुए मूल राशि ब्याज सहित वापस कर दिया गया. पैरा 58. मनीसूट 45/1983 में निर्णय के आलोक में कहा गया था कि बाद में न्यायालय कन्वेयर बेल्ट के माल आपूर्ति का आदेश नहीं दे सकता. न्यायालय को उपरोक्त आदेश 1992 में हुआ था. 1992 में हुआ था. न्यायालय के द्वारा निर्णय देने के 1 महीना बाद बोकारो इस्पात संयंत्र को माल आपूर्ति के लिए एक पत्र दिया था. वह पत्र न्यायालय में दाखिल नहीं किए, वह पत्र दाखिल नहीं कर सकते. काइंडली मार्क पैरा 60.
आप कोई 61 ठीक से पढ़िए.
यस, ऐसी बात नहीं है कि न्यायालय के आदेश के पश्चात हम लोगों ने कोई पत्र बोकारो इस्पात संयंत्र को नहीं लिखा था. माल आपूर्ति किया जाए इसलिए न्यायालय में पत्र दाखिल नहीं कर पा सकता हूँ. गवाह पूरा कहते हैं कि कैलाश कॉर्पोरेशन के कार्यालय एवं दस्तावेज से लेकर न्यायालय में जमा कर सकता हूँ.
ये बोल ही रहा है कि आई कैन नॉट फाइल एनी सच लेटर.
बट मैं करेक्ट, ऐसी बात नहीं है.
नहीं, ऐसी बात नहीं है.
ऐसी बात नहीं है. स्टार्ट फ्रॉम नेगेटिव कनोटेशन कि नहीं, ऐसी बात नहीं है कि न्यायालय के आदेश के पश्चात हम लोगों ने कोई पत्र नहीं लिखा.
ठीक है.
So इससे
आगे कि इसका मतलब लिखे थे
आपूर्ति किया जाए.
हाँ.
इसलिए न्यायालय में दाखिल नहीं कर पाता हूँ. मैंने हमने क्वेश्चन पूछा कि आपने जानबूझ के नहीं दाखिल किया. बोला नहीं, ऐसी बात नहीं है कि हमने चूंकि लेटर नहीं लिखा इसलिए हमने दाखिल किया. मीनिंग देयर बाय ही सेज कि हमने लेटर लिखा.
तो दाखिल क्यों नहीं किया?
दैट
दाखिल नहीं कर पाता हूँ ना. देयर इज नो सच लेटर.
मतलब
दैट इज
thereafter he says, गवाह पुनः कहते हैं कि कैलाश कॉर्पोरेशन के कार्यालय में दस्तावेज को देखकर न्यायालय में जमा कर सकते हैं. He
कौन
says
सा
letters
document?
have been written, but अभी नहीं है. From the office he can get the letter and he can file. That is.
But letter has not come into existence. Next, para 62, most important. Wadi Prem Kumar जीवित है. Kindly mark that. And he is unable, infirm, cannot come to the court, and for what reason he could not be examined, kahin nahi. So the plaintiff was alive. I can today argue that he has purposely not entered into the witness box. PSL द्वारा जो टेंडर हुआ था, प्रेम कुमार, जो भी टेंडर मिला था, प्रेम कुमार को मिला था. मैं उक्त कैलाश कॉर्पोरेशन में किसी पद पे कार्य नहीं किया था. इस बात में संलग्न दस्तावेज देखकर मुझे जानकारी है. पूर्व में भी मुझे इसकी जानकारी थी. बीएसएल द्वारा जो भी पत्र निर्गत किया गया उस समय मैं वहां उपस्थित नहीं था. वादी जब टेंडर आवेदन दाखिल किया था उस समय मैं सोचा था, मैं साथ था. वह एडीएम बिल्डिंग में डाला गया था 26/9/1979 को. उस वक्त मेरे पास बना था, उसकी कॉपी न्यायालय में दाखिल कर सकता हूँ. नेक्स्ट, वादी कंपनी का नाम कैलाश कॉर्पोरेशन. मुझे दिनांक 26/5/16 को जो मुख्तारनामा दिया था उसके पूर्व वादी ने किसी और व्यक्ति के नाम मुख्तारनामा दिया था कि नहीं मैं नहीं जानता. वादी द्वारा टेंडर फॉर्म भरे गए, टेंडर पे मेरा हस्ताक्षर नहीं है. वादी कैलाश कॉर्पोरेशन अगर आपराधिक मुकदमा 1980 में प्रेम कुमार पर मुकदमा नहीं हुआ था, परंतु कांडी पैरा 70 leadership will see there was no case against Prem Kumar, and the Prem Kumar was the successful bidder. Para 70 वादी कैलाश कॉर्पोरेशन के ऊपर आपराधिक मुकदमा 1980 में हुआ था. मालिक प्रेम कुमार पे मुकदमा नहीं हुआ था, परंतु अन्य कर्मचारियों पर आपराधिक मुकदमा हुआ था. किन कर्मचारियों पर पीड़ित हुआ था मुझे याद नहीं है. 1980 में वादी कर्मचारियों के अधिकारी पे यह आरोप लगा था कि पुराने माल के बदले नया माल ले जा रहे थे. इस वाद में जितना भी दस्तावेज दाखिल किया गया है वह वादी प्रेम कुमार की तरफ से दिया गया है और उसे मैंने दाखिल किया है. X/1 X/2 कब और कहाँ बना मेरे सामने या नहीं बना, इसलिए मुझे इसकी जानकारी नहीं है. Now, what is X/1 and X/2? Yes.
आप जरा हमको ये बताइए, एग्जिबिट 10 का कोरस्पॉन्डिंग स्टेटमेंट कितना है?
एग्जिबिट 10 वो रिकॉल के बाद आया. रिकॉल विटनेस जो है
पैरा 7 और
रिकॉल होने के बाद पैरा 7. May I read para 6 and 7 both on recall? Yes. Para 6, this is the most important thing. यह कि वादी और प्रतिवादी कंपनी के बीच 714.82 मीट्रिक टन सप्लाई का करार 1980 में हुआ था, जिसमें से प्रतिवादी ने सचिन से सप्लाई किया. नाउ 37/1980 के पश्चात लगभग 43 वर्ष बीत जाने के बाद भी नहीं किया, जिसके कारण 1980 का यूज सोल्ड वर्तमान में उपयोग करना असंभव है. So they don't want to perform the contract. इसलिए वादी कंपनी नए यूज कन्वेयर बेल्ट को करार दर पर पाने का हकदार है. So they themselves say that the contract has frustrated. 43 years is a long time. जो सामान था भी एक जगह बोले कि बेच दिए और अब बोलते हैं कि वो यूजेबल ही नहीं है, इसीलिए वो नया लॉटेड साइज से आते हैं. देन पैरा 7 वादी कंपनी ने प्रतिवादी कंपनी को भेजे गए 10/2/1993 की मूल कार्यालय प्रति न्यायालय में दाखिल किया है, जो कि 2 पृष्ठों में इसे मैं पहचानता हूँ प्रदर्श दर्शक के लिए.
Nothing about this. What was the content? What was the occasion? Nothing mentioned about this. It is just जो रीट में annexure लगता है उस टाइप का statement. ये 50,000 रुपए का आपको पॉइंट चाहिए.
Yes, 50,000. When this 50,000 has become due?
When does it become due? Just tell us.
When they have demanded either to perform. I will read from the plate itself. Para 19. What was the demand? Para 19 complaint referring the legal notice of 16/7/1983. Either refund my money or resume supply. I have not done so.
That's right.
Then they come.
Just a moment.
Yes.
They filed a suit.
Yes.
The court said that since the contract is subsisting,
Yes.
therefore I will not refund you the
Yes.
security.
Ah.
So thereafter, when did the contract frustrate?
Yes.
According to
1992, they have said, so the claim is now money. What is the period of limitation for a monetary claim? 3 years. So at best, when the liberty was granted by the London Trial Court in that money suit 45 1983 or whatever, in 1992, the cause of action arose that they are entitled for the refund. And the article
no,
44,
the cause of action arose that they are entitled to the material.
material if they want.
If they want, naturally.
The word is action. May I read once again? Action means optional. The judgment para 7,
Yes,
it
yes,
says,
certainly if they want.
if they want, they can approach us. So they never approached us for next 22 years. And if something has become, if they have not approached us for 20 years, would their claim for money will survive for another 20 years, 22 years? It's a 1992 judgment and 2015
So I
is,
just want to know,
Yes.
when did the
even
agreement
if,
frustrate,
even if
or when did the agreement terminate?
it's not required, due passage of time, what I mean to say, leadership may see the contract. Section 46, when even if no time is provided, the performance is always reasonable.
Within reasonable time.
Well, what is reasonable depends. 46 years cannot be said to be a reasonable. Section 46. Time for performance of promise, where no application is to be made and no time is specified. This is their best case, whereby the contract a promisor is to perform his promise without application by the promisee. That is their best case, and no time for performance is specified. The engagement must be performed within a reasonable time. The question, what is a reasonable time, is in each particular case a question of fact. So what is the reason? My argument is that even if it is found due in the year 1992, that they are entitled for both.
Where is the clause regarding refund of security money?
There is, I can say that there is no such clause. I have tried, the same exhibit to leadership I will again, but I have tried to see, there is no such clause of refund of security money. A clause 2 somewhere discuss about the security deposit. Problem is may I read earnest money, which is clause 2? May I read that?
Just yes.
The tender should be accompanied by earnest money deposit to the extent of 1% of value of store's tender for purchase in cash deposit with senior accounts officer, sale Bokaro, such and such city in favor of sale Bokaro, and the money receipt attached with tender in taken of
In token of deposit.
in token of deposit, check will not be accepted towards earnest money deposit. It is not also possible to adjust earnest money from any sum money due from the plant on account of pending bill, security deposit, or earnest money paid towards this tender. So this is the earnest money at best. They say in that is their what security deposit everywhere. The contract never says security deposit. There is 1% earnest money deposit. I have not placed a counterclaim, but had I not suffered a loss when you have not lifted that amount, and I was forced to go for a second tender and then to supply to somebody else.
You see para 5B.
The earnest money deposited will be forfeited if the tender, after acceptance of his offer by controllers, who fail to comply or vitiate the terms of condition of tender in any manner drawn during the period of 6 months. So that is
Now you
again
come to 12B.
12. In event of failure to complete the payment of sale value of this
Yes,
said
12A.
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 Said money by the purchaser within stipulated period, the sale of such material will be cancelled, the security deposit for such and such shall be forfeited or otherwise disposed of without any notice to purchaser.
So
and
therefore,
yes,
your action to dispose of the material is admitted.
yes,
So therefore, you have exercised your power under 12A at best.
yes, without notice I have
At best.
and for that I could not issue any, as per the terms, I was not required to issue you notice or to give you any opportunity of whatever, maybe it is valid at term or not challenged. So this amount, we cipher that. See, we cipher. But this is not the limit.
ये आपका approach was सही नहीं है.
Even if that is all I had to say. That something which was due, acknowledged and crystallized in the year 1992 by a court of law. That
was what do you have to say?
In 1992, there was a clear finding that security deposit cannot be returned because the contract has not been terminated. So
By that time, the contract was not terminated.
not terminated. So ideally, security deposit they ought to have returned to me once the contract was terminated. So the contract was never terminated till date. If they are saying that contract got frustrated or they have forfeited the security deposit, there has to be some pleading, some evidence for that. They can't blankly come and say in the arguments. Where is the evidence that
When
it
did
was
they start
forfeited?
selling to third parties? It was there in the earlier money suit also.
1982.
Yes, prior to money suit.
Prior to money suit.
Prior to
So you were
even
not
after.
agreed by that?
Because they said that we are still ready and willing to supply once the criminal case is over.
Where I have said so.
That is what is there in the 92 judgment.
That is with respect
That
of
is
balance.
there in the 92 judgment.
That's right. Anything else?
They could have said the contract has got frustrated in 92 itself when the judgment was being passed. And at that time they could have refunded me 50,000. But they maintained the stand that the
My
contract
only
still can be
submission is
performed.
that refund of security deposit can only be made when there was a valid and effective contract still alive. If that contract is not alive, then nothing can be paid.
आज आपको घर चाहिए, थोड़ा होमवर्क करिए, 2-3 चीज़ करेंगे. एक तो थोड़ा सा बेसिक कंक्लूड्स, आप खाली पैराग्राफ कौन सा आप रेफर कर रहे हैं एविडेंस का, यू जस्ट रेफर टू द पैराग्राफ. शॉर्ट नोट चाहिए लिखाने के लिए. ठीक है, पॉइंट ऑफ डिटर्मिनेशन आप एक्सचेंज कर लेंगे और वी विल जस्ट फ्रेम द पॉइंट ऑफ डिटर्मिनेशन एंड डिक्टेट द जजमेंट. हो जाएगा?
But if that
कर लीजिए, इतना तो कर लीजिए, थोड़ा कर लीजिए. छोटा नोट बना लीजिए, 2 पन्ना का नोट बना. Arguments concluded. The learned counsels to file short synopsis of maximum 2 pages each, right, based on the arguments advanced during the course of hearing, and the judgment will be dictated in their presence tomorrow at 2:15. कल इसका आखिरी दिन है. अब 4:30 बजने वाला है, अभी शुरू नहीं कर सकते.
Just one more day for the note. Just one more day.
क्योंकि देखिए क्या प्रॉब्लम क्या है. If I start with another second appeal tomorrow, ये वॉशआउट हो जाएगा. ऐसा नहीं करना चाहिए. थोड़ा सा करिए, मेहनत हम भी करेंगे.
One more. Our prime contention remains that even in 92 when the judgment was passed, the contract was subsisting as per their rules.
As per the judgment,
As per the judgment.
what was about what was their stand. As per the judgment, the contract was
It attains
subsisting.
finality, they never
Then the
challenge.
again question is how much time it will set to be subsistent.
देखिए, आपने तो रिटन स्टेटमेंट नहीं फाइल किया कि कॉन्ट्रैक्ट फ्रस्ट्रेट.
हाँ, but the book can take note.
We will take note. Orders का केसेस 250. फर्स्ट अपील फर्स्ट हाफ में नहीं करनी. हम लोग का ये ओल्ड केसेस वाले कितने मैटर्स हम लोग टेकअप नहीं किए. 4 केस बच रहा है, दिखाइए तो सर.
Date से 5 to 8.
इससे पास तो नहीं होंगे. कोई बात नहीं, चारों केस कर देंगे. चलिए नेक्स्ट कॉल करिए ऑर्डर्स.
From supplementary list for orders item 6 second appeal 0019 of 2022.
Yes, why is it listed for orders?
Respondent number 6 and 7 for giving notices to their applicant in another case. So इसमें लिखा हुआ है कि notice देने से इनकार
नाम लिखो.
Respondent number 8 की ऐसे कोई validity है.
Respondent number
6 and 7.
6 and 7.
Yes, please.
Respondent number 6 to 8. You have filed the affidavit? Essay filed? Not filed. Why have you not filed? Where is the supplementary affidavit?
Yep.
A personal service?
Notices filed on 30th June 2025.
The personal service, 10 दिन का काम.
Yes, yes. We have filed it. That has been served on 16/7/2000.
कहाँ?
Refused to receive.
Where is that? Affidavit, you have filed it.
On my record, unfortunately, it was presented before the learned lawyer who was appearing. He refused to accept it in
No,
writing.
but asset कैसे? आपको affidavit में file
That's
करना होगा ना.
That's okay. So it only simply pass over for date, so that I can.
Essay number 119 of 2022. Counsel for the appellant. Praise for
Only
1 week time to
2 days time, so that I can.
praise for 2 days time.
File the supplementary affidavit along with the service.
File supplementary affidavit in connection with service of notice upon respondent number
6 and 8.
6 and 8.
6 and 7. 6 and 7.
6 and 7. दोनों मोड था ना.
अब तो notice कर चुके हैं. That I have steps have been taken. Pursuant to the order dated 20th June 2025, 30th June 2025, we already filed the requisites. And in addition to that, the service lawyer. The office notice there, no? The steps, the notices have been
So
issued.
क्या हुआ उसके बाद? As per the office note, the notice has been served or not served?
The summon was in addition to the notices.
Ordinary process notice upon respondent number 6 was served through learned advocate as directed by service report S5 तो है इसमें? Service report of respondent number 6. Received summons of respondent number 6 का तो served है.
Respondent number 7.
उसके बाद में expenditure. आप उसका फाइल कर दीजिए. रिफ्यूज किया वही.
6 का तो स्टार्ट हो गया.
Learned counsel for the applicant pays for 2 days time to file affidavit regarding service of notice. ठीक है? Service of dusty notice.
Yes. So, but 6 is concerned, it is.
देख लेते हैं ना. अब 6 को भी तो आपको देना था ना.
ये लेकिन रिफ्यूज कर दिया.
कोई बात नहीं.
वहाँ
रिफ्यूज
receive
कर
किया.
दीजिए ना. रिफ्यूज कर दीजिए. आप फाइल कर दीजिए, उसको एक्सेप्ट कर लेंगे. क्या चल रहा है एग्जीक्यूशन में जो इतना रिफ्यूज कर रहा है? ये वाला को
डिले करना चाह रहे हैं.
जिसमें रिजर्व हो ना.
वो लोग डिले करना चाह रहे हैं कि डिलीवरी ऑफ पोजीशन दे. बाकी सबको एफआईआर किया है. कंटेस्टिंग आदमी यहाँ एफआईआर कर. इसमें लिस्टेड नेक्स्ट वीक एनी डे.
हाँ नेक्स्ट वीक आप पता है कौन सा दिन चाहिए?
जो मंगलवार को.
Tuesday in supplementary list.
Yes.
Next.
From daily list for order will be different item 12, 2nd April 5 to 4 of 2017.
ठीक है.
In this case, the one defect may be, the value of the suit,
Why?
because there is no value of the suit has been.
तो कोई सूट नहीं होता. Damages का भी valuation.
It is arising out of the CNT Act, the commissioner order. Against the commissioner order, this has been filed, because the value of the land is not given in the court below also. Therefore,
वो 87 की कौन?
revenue, sir. So if that may be ignored,
ठीक है. Essay number 524 of 2017. The learned counsel for the applicant has submitted that the appeal, though is second appeal, but it arises out of, but it is an appeal under section 87 within bracket 2 of Tobacco Tendency Act relating to entries in record of right. The learned counsel submits that the defect regarding valuation may be ignored.
Other
Considering
defect
the
has been
submissions,
other defects have been.
considering the submissions, the defect regarding valuation
Defect number
2 is ignored for the
8.
present,
defect number 8.
which is relating to defect number 8
Yes.
is ignored for the present. You have file बनाइए also.
Yes, Lordship, there is a limitation.
आइए
IA for limitation, IA for lordship substitution. And there is also limitation also there.
उनको fresh stamp voting करना है. Office is directed to proceed and list this matter under appropriate heading on next Wednesday.
Next.
Wednesday.
Item 13. SA 245 of 2023.
Essay number 245 of 2023. And in section 87.
Item 13.
इसमें भी valuation का defect हुआ. Time till 8th of September is granted to the applicant to remove the surviving defects or to file an appropriate petition in connection with one or the other defect. Preemptive. If this order is complied, post this case under appropriate heading on 15th of September.
Item 14. Second appeal 253 of 2023.
Okay. Judgment है क्या इतना मोटा? ये जो preemptive order है तो कैसे नहीं है dismiss हुआ? Why? There is a preemptive order for removal of defect. The appellants are directed to remove the defect as pointed out by the on-stamp reporter within 8 weeks. Failing which, this appeal shall stand dismissed without further reference to bench. IA for what? Nobody appears. Date दे दीजिए. 8 सितंबर. नहीं कुछ नहीं बोल सकता. आगे है तो 8 सितंबर.
Item 15. Second appeal 289 of 2023.
Defective. Same order कर दीजिए. 8 September. Nobody appears 8 September.
Orders item 16. Second appeal 39 of 2015.
This is also defective.
Orders.
Whom are you representing?
So I file an IA for getting the appellant as a respondent in his present second appeal.
Appellant as a respondent.
Lordship. I am the valid purchaser from Mr. Zubedar.
So you were the co-appellant.
which in the lower court I was the co-appellant, and here I completed.
क्या हुआ?
So at para 6 of IS petition I have mentioned the reason for.
Order 1/10 का petition आपने फाइल किया. अभी आप रिस्पोंडेंट है ना?
Lordship, उसी के लिए एप्लीकेशन दिया IF फाइल के जो एज अ रेस्पोंडेंट ऐड किया.
जब तक अपीला नहीं आएंगे कुछ नहीं करेंगे. यहाँ हम लोग अपने से बैठ कर फाइल भी पढ़ सकते हैं. Where is the appellant? This is of 2005.
Yes, 2005 matter and may not, still some steps are not taken. Last time I have
ये
seen the
20
reports.
years में नहीं आएगा. Yes.
कुछ नोटिस सब्सक्रिप्शन सब कुछ
ये 20 years में आना चाहिए ना. बस हेडिंग चेंज करके कल लगा दीजिए इसको. 20 years वाले में है.
तो ऑर्डर ही रहेगा
2005 का
This case is more than 20 years old.
exact case
Office is directed to place this case under appropriate heading of बताइए target cases,
target case
targeted cases
targeted
tomorrow. किसी भी स्टेज में हो केस 20 साल हो गया है तो टारगेटेड केसेस के
इसीलिए
ही
हम
हेडिंग
लोग
में
को
उसको
बोले कि
डालिए.
बहुत साल से पड़ा हुआ है एडमिट हो गया